All right. So discussion of topics, the recommendation to Standards Commission. Ms. Leslie, who be presenting at you?
Sorry, I lost my internet there for a minute, Mayor Colvin. Let me share my screen. This is the right one. Yeah. So where we left off, and I think that we have two things really to cover. One is the recommendations to the Standards Commissions regarding the standards for entry, decertification, and data collection. And then the other is talking about psychological evaluations. I thought it might be helpful, Mayor Colvin, if I could go over with the group just briefly what the minimum standards are and what the revocation standards are, just so we'll have a baseline for our discussion, if that's all right with you.
Yes, ma'am.
Okay, so I'm going to share a different screen here. So this should be sharing the minimum standards for criminal justice officers. So the standards for police officers and highway patrolmen and corrections are all under the Criminal Justice Education and Training Standards Commission, and then of course Sheriff's has its own. All of the police officer standards are in 12 NCAC 09B. All of the corrections are in 12 NCAC 09G. And then all of the sheriffs are in 12 NCAC 10B. So the 10Bs are sheriffs and the 9Bs are police officers, generally speaking. So here, and most of them mirror each other fairly closely, but I think that's something for us to talk about in our recommendations. Where they don't mirror, do we want to make that recommendation that they do? Looking here at the minimum standards for criminal justice officers, it's a lot of things that you would expect to see. I just wanted to bring your attention to a couple of things. Currently, right now, in 12 NCAC 09B subsection 3H, and I've got it highlighted down here, one of the things that police officers can't do is not engage in any conduct that brings into question the truthfulness or credibility of the officer or involves moral turpitude. And then there are a lot of cases that talk about what moral turpitude is. Some of those cases do in fact involve physical violence. So just for your frame of reference, some of them involve sexual activity, some of them involve physical violence and domestic violence contact, that kind of thing. But nothing specifically talks about use of force within this part of the code. That's about as close as we get to use of force in this part of the code. I flagged down here just so that you know this is the requirement in CJ that has for the psychological screening, which is not present in sheriffs, and that's the second part of our discussion today. But for the first part, I just wanted to draw your attention to moral turpitude here, and then I did not share that with you, so that now you can see it. Here we go. Moral turpitude is here. Not engage in conduct that brings into question the truthfulness or credibility of the officer involving moral turpitude. And of course, there are lots of other things as well, including not commit or be convicted of any crimes or certain crimes, and then drug testing and all of that, which I don't think is what we're really talking about here today. But anything involving use of force to this point that comes before the commission would generally fall under the moral turpitude bucket. When it goes to sheriffs, it's going to be here in their 10B 0301 minimum standards, and their moral turpitude is a little bit different. It says be of good moral character, but if you spend any time studying it, you'll see that the list of cases is the same. So even though it's good moral character in one and moral turpitude in the other, the list of cases that kind of frames that reference for both CJ and sheriffs is the same type of conduct. None of that explicitly includes either use of force or abuse of power type instances. And so these are the minimum standards for entry. So these two provisions I've just showed you are, this is what you have to have in order to come into the profession to begin with. Then once you're in the profession or once you're working for an agency, then there is a provision in each code. And now you should be seeing 10B 0204, which is suspension, revocation, or denial of certification. And this is the sheriff's code provision. And so each of the codes say that you can revoke, deny, or suspend the certification of a justice officer when the commission finds that they failed to meet or maintain any of the employment standards. So basically, the two code provisions inform one another. So I just showed you the minimum standards, and then this suspension, revocation, denial says, if you don't meet the minimum standards, we can suspend, revoke, or deny. Again, this provision does not have within it anything specific to either use of force or abuse of power. Looking here at the same provision for CJs, 09A, 02, 04, you look at fails to meet or maintain one or more of the minimum employment standards in 09B 100. So that's what we just looked at. So each provision refers back, but again, does not have a specific provision for use of force or abuse of power. I will also note that CJ, unlike the Sheriff's Code, CJ does have a provision that you can suspend, revoke, or deny if the person has been discharged by a criminal justice agency for commission or conviction of, and then it has any other offense involving moral turpitude. So theoretically, those types of actions on behalf of an officer could fall under that category. But again, it's all at the moment up to the interpretation of who is bringing it before the commissions to look at the officers or the sheriff's deputy's certification for these things. So with that context, the recommendations to look at, and I think, are you guys now seeing the recommendations that I have up on the screen? It says part 5, okay. So the first one is to support the RAP Back program, and I should have shared that with you also. That's on the screen too. RAP Back, as we touched on briefly, and some of you may be familiar, is a program that essentially says when officers commit a crime or are fingerprinted in another state, that we want to be able to have a fingerprint record check. It would require a revision to the code. This code revision that you're seeing on the screen is proposed by the SBI currently. And so they have proposed that the fingerprints and accompanying information of the application for certification pursuant to this rule may be maintained and stored electronically by the SBI for purposes of ongoing assessment of certification status. Within 15 business days of receipt of a report of separation form F5B, the sheriff standards will notify the State Bureau of Investigation of separation. And then this is the code provision down here for record check, essentially allowing the SBI to get those fingerprints for RAP Back. Then the code, essentially, this would be a new statute that would need to be enacted to support the RAP Back. I will tell you that both commissions at this point have already supported RAP Back, and it's just another way to make sure that we are aware of what officers' status is in relation to the commission or conviction of any crimes. And so perhaps for the task force, this, and I know that we hate to use these words, but this might be one of the ones that's a no-brainer, in that if both commissions have already supported it, I think it's important for us to consider whether the task force wants to support it as well. And so that was also in your pre-work packets. You have access to that. So one of the questions for discussion today is first, whether we recommend support for the RAP Back program that's been proposed by the SBI in terms of the code revisions for both commissions and also the legislative changes that would need to occur that the SBI has drafted. Then the other questions that I have drafted proposed solutions, proposed recommendations, but can of course be changed or amended as needed, are to recommend that the commissions revise the minimum standards to require that officers not engage in excessive or unjustified use of force or abuse of power. And then also the provisions I just showed you with respect to suspension, revocation, or denial to allow them to be revoked or denied based on excessive use of force or abuse of power. So the first, that kind of covers the first three. And then after we get through those, I think maybe we'll go into the fourth one, Mayor Coleman. I think it's probably a good place to separate, given that number 4 talks about what the standards divisions would need to do to collect any data. So I think we might need to make some decisions before we request what the standards divisions do. So that's kind of the tee up for the discussion of the first 3 parts here.
Okay, thank you, Ms. Leslie. You know, this is a lot that involves the practical application from law enforcement. So with Chief Davis, I don't know if Sheriff Ingham joined us, but I'd be interested to hear from Chief Davis what your perspective what's your perspective on these changes?
Well, much of what has been discussed, as Leslie mentioned, has already been part of conversations amongst law enforcement around the state. And I think what is being recommended here is basically that we adopt some of the themes and concepts that many of our law enforcement leaders have already endorsed. This one ought to be easy. I know, Leslie, you've done most of the deep dive into looking into the comparison of our recommendations and existing policies. And I think this is an easy one for us.
Okay, I like easy. Representative Galliard?
Yeah, I'm definitely in support of these. I would be curious to know, Chief, and I appreciate the fact that you are in support of this. And have you heard discussions amongst people that were not in support of it and what their perspective was, or is it generally pretty well accepted amongst your profession?
I think those individuals who entered this field with the right intentions support policy recommendations, like this. And I would say that's the majority of folks in leadership. And folks who don't support it, I think they won't be very vocal about it, because we believe that most leaders don't want individuals in your police department that present problems. And these various elements here will help eliminate the continuous movement. And we've been talking about the wandering officer, the continuous movement of officers going from one agency to the next. So this is really huge for us.
That's great to hear.
Mm-hmm.
Good then, Mayor.
All right. So with that, as it relates to the first few recommendations, we get a motion to approve as presented.
So that's recommendations 1, 2, and 3. Is that correct?
Yes, that was my understanding. Everything, let's take a review of it. If there's one that you had a question about, but I wanted to probably address everything that was presented by Ms. Leslie a few minutes ago.
So one would be to support the Rat Back program, which has already been supported by both commissions. 2 would be to ask the commissions to amend their minimum standards to require that officers not engage in excessive or unjustified use of force. I think that it is implicit in those minimum standards as they exist, but I think that this is us speaking truth to it, right? We're saying that we want it to be explicit. And so we're asking them to be explicit as opposed to having it be implicit. And then recommendation 3 is to the revocation portion of the code. So once someone is already an officer, when you can take their certification away, we are asking that the commissions add a portion into that statute, into the administrative code provision, to allow them to take certifications based on excessive use of force or abuse of power. I think the things that will need to be decided by the commissions are, what are the definitions of excessive use of force and abuse of power? And I think that will get a lot of discussion in the commissions. And I think that they will have lots of opinions about that. I certainly think the Chief can attest to this. Our committee, I think, would probably have a lot of thoughts about those definitions.
Absolutely.
And we could recommend, as a working group, we could recommend to the task force, who could then recommend to the commissions a definition for what we think is excessive or what we think abuse of power is. Or we could allow the commissions to come up with what they believe that definition is. So I think that that's maybe the only outstanding decision point, if it sounds like everyone is generally in agreement with those these three recommendations.
So let me ask a question. As it relates to this now, like you said, it's kind of implied, but this would be a little bit more direct. If there's a use of force case, how does it get referred up for the Standards Commission to review? Because as we talked about those review boards, and I text you kind of a discussion that was taking place in our area the other day, would a review board, if that comes to fruition across the state, be able to refer a case that they believe fits excessive force once it's defined? How do you refer somebody to the Standards Commission?
Yes, sir. So I think we can, in several different ways. I think that the first way is that if there is something that rises to the level of a crime, the commission of a crime can be represented or can be pushed to the commissions for consideration. The commissions don't just have to look at conviction of a crime, they can look at commission of a crime. So if a use of force incident happens and we believe that it is commission of a crime, that can get referred to the standards division and they would open up a probable cause investigation, and that would start the process of going through the whole commission process there. Conviction of a crime could also refer it to the commissions, either commission, for, again, a probable cause determination and moving it through the process from there. But also the way that this working group, and that has been adopted now by the full task force, have set forth our recommendations for civilian oversight boards. We have recommended that civilian oversight boards be able to make recommendations to the standards commissions as well. So theoretically, under the structure that we have asked for or think should be the way things operate, that the civilian oversight boards would be able to say to the commissions, we believe you should open up an investigation into X conduct. So that certainly could happen. There are other ways that the conduct can come before the standards commissions. I mean, if an agency head, for example, if Chief Davis believed that the conduct of one of her employees rose to the level of an investigation, she could refer it to the standards divisions for investigation. So, and then also, sometimes these incidents come to light when an individual tries to either change commissions, and of course, changing from the CJ commission to the sheriff's commission. So moving from becoming a police officer to a sheriff's deputy requires you to change your certification, and it requires a new investigation, and vice versa. And so when that happens, your conduct is up for grabs. And in the investigation, if they found something in your conduct, in your history, that the staff of the divisions thought should go before the commissions, it could go before the commissions that way. And then also, if someone changed from police officer to police officer or sheriff's deputy to sheriff's deputy, so they didn't change commissions for certification, but they changed agencies, and I know that this is very convoluted, but if they changed agencies, that right now does not mandate that they go before the commission for a new review. But if the new agency head, if the hiring agency head found something in that process that they thought should be referred to the commission, they could refer it to the commission in that process if something was uncovered, like a pattern of misconduct or something like that. So I think there are a lot of different ways conduct gets before the commission. I've probably missed some, but those are the ones that come to mind.
So last thing I'll say on this, so the commission of a crime piece as it stands right now, it means they have to be charged, like, so assault, or if you believe that, God forbid something happened and someone was assaulted, is that a case that could be referred up there even if it hadn't been charged?
Theoretically, yes. It does not, commission of the crime doesn't necessarily mean charging. It usually does. Usually it means you were charged, but maybe you pled to one thing but not another, or you pled down from something to a misdemeanor that doesn't revoke your certification, but perhaps there's this commission of other conduct out there. So it's usually a charging situation, but it does not have to be under the word commission.
Okay. All right. Any questions from you all on recommendations 2 or 3?
I would say that the success of this is really going to have a lot to do with the defining number 3 and the leadership of police departments to ensure that reporting is done. Because, instead of an agency handling something in-house, it could potentially never get to the commission unless we make sure that the wording is sort of a mandate that is reported to the commission. And Leslie, I know that's probably some more of the back work that would need to be done maybe from the commission standpoint, but I think as it reads, it captures what we would like to see happen as it relates to the suspension or revocation and denial of certifications from individuals with excessive use of force. Also, in reading that, would this mean those cases that are sustained, Leslie? Or would that be up to the department to make a referral on, say, for instance, a person has 3 different incidents in a year and none of them were sustained? But does that indicate there's a pattern potentially? Because sometimes cases aren't sustained because we just don't have enough, information about what occurred and it could have possibly happened. So, I guess the trends or a pattern would probably come into play at some point too.
And I think, Chief, that's up for grabs. As we have it drafted here, we don't limit that. We don't say that you can't consider a pattern. We don't say that you have to consider a pattern. We haven't, these 3 are not yet that specific. Certainly, if you guys want to revise them to be that specific, we absolutely can. That's something the commissions can definitely consider. I also think, Chief, that could still fall under, if there was a pattern issue, that could still fall under moral turpitude, theoretically, in some situations. To your other point, which I think is an excellent one, down here, the wandering officer issue is only solved if agency heads are participating in the solution. And so they have to do the checking of the officers they are hiring. And so further on down here, number 4, one of the proposed recommendations I've put up here for you is to recommend that the standards divisions revise the code to require the hiring agencies to contact standards and get that information. You can't require the agency head to hire somebody or to not hire somebody, but you can require them to get the information, theoretically, if the commissions would agree to amend the code to include that. So that could also help with the wandering officer issue. So I put that down in number 4. That's certainly up there for part of that discussion as well.
Thank you.
All right. Do we have any further questions? Can we get a motion to accept the recommendations that we've discussed?
You're muted, Chief.
Okay, I was just making a motion here that we accept recommendations 1, 2, 3, and are we moving to 4 as well?
We haven't discussed 4 yet, but so I haven't gone into the explanation there as of yet.
Okay, well, I'll just stick with recommended solutions 1, 2, and 3.
I'll second the motion.
All right, there's a motion properly seconded to accept recommendations 1 through 3. Any discussion on the motion? All those in favor, hands or aye? All right.
Aye.
Motion carries unanimously. All right, Ms. Dismutes.
And Mayor Colvin, I will just let you know that I got an email from Sheriff Ingram's assistant. She had emailed another staff member, but he was not able to be there today. Something came up. Not able to be here today, something came up. So just FYI for you. The last recommendation, or the last 2 recommendations under the standards, and of course, there can be any number of recommendations. These are just recommendations I have teed up for the working group to discuss. If there are other recommendations, certainly those are also things we should consider. 4 is to recommend that the standards commissions revise the notification provisions that are contained within the minimum standards provisions to require notification by both the officer and the agency when an employment action is taken against an officer because of the use of force. So right now, there are certain notification provisions within the minimum standards that have to be made. For example, in the CJ version, in 09B 0101, the officer has to notify the standards division of all criminal offenses that the officer is arrested for or charged with, or pleads no contest to, or pleads guilty or is found guilty of, as well as any 50B order that's issued by an official. And then it goes on to list, what types of offenses are included there, and say that they should be in writing, etc. And then it requires officers to also notify their employing agency, executive officer, the agency head, and then the agency head, if they have knowledge of it, then has to also notify standards. So right now, the notification process is that if an officer is arrested, charged, pleads or found guilty, or has a DVPO, they have to report that to standards, regardless of the outcome. They have to report it to their chief or sheriff, and the chief or sheriff, if they have knowledge of it, of course, that assumes the officer does what they're supposed to do, then also reports to standards. So looking at number 4, this would ask to expand that to use of force incidents if there is an adverse action taken for use of force. So if there's a use of force that is clear, that is not sustained, then I think that is not necessarily what we're talking about here. If there's an incident, because use of force, doesn't always necessarily mean something bad happened as a result of use of force. But if there's an employment action taken, or we could change the language to is sustained against an officer for use of force. Chief, you would probably know the best language there to use. Requiring the officer to notify both the commission and requiring the agency head to notify the commission. And Mayor Colvin, that gets to your earlier point about how the commissions find out about these things. This would be one more way to mandate reporting. It is an additional burden on the officer, and it's also an additional burden on the agency head. So being real clear that that's what we would be suggesting, it does create a burden on both of those sets of individuals. And then the subparts there are to recommend the standards division keep track of that, basically keep track of these use of force reporting by the officers and the agency heads. And then further that the commissions revise the code to, and then subsection B is what I was just talking about with the chief, is to require that the hiring agencies contact the standards division to, inquire about those use of force incidents before they hire someone. And then, of course, the last recommendation under C would be that to initiate an investigation when the above defined use of force incidents happen. So basically what 4 contemplates is that if there's a use of force incident that's sustained against an officer, that the officer has to report it and the agency head has to report it to the commissions. Then the commissions have to investigate, and it goes through the commission process to determine whether or not it revokes, suspends, or denies that certification. And then also that the commissions have to keep the database of those reports, and that the agency heads have to check with standards before they hire a person. It doesn't say that it keeps the agency head from hiring that person, but it requires them to check. So that everyone knows what they're getting into with a particular person who may have this issue.
And Leslie, I would use that language in that first paragraph, that, as you mentioned, because of a sustained use of force. In that last sentence, before you get to A.
Mm-hmm.
What's the difference between that, Chief? What does that mean?
That means that the commission won't be inundated with just use of force. We get use of force allegations, all the time. You can say, somebody can say he scratched my arm while he put me in the car, and it may not be sustained. And you just don't want to inundate the commission with the very minor or frivolous kinds of complaints. A sustained use of force, I would think, would be that the investigating agency has found that there was egregious action against an officer, and there was some type of disciplinary action that took place. And then we're going to forward that to the commission to make a determination of whether or not this person's certification should be threatened. Am I on point with that, Leslie?
Yes, ma'am. And also, so that is definitely the first part, whether they should threaten their certification. And then if the division is keeping track of this, the standards divisions are keeping track, it also allows us to establish a pattern. If an officer is an agency hopper and has one at each agency and then moves on, if the standards divisions are keeping track of that, a hiring agency can look and see a pattern there that might suggest that they're in the wrong profession.
Well, I just have a question on that point. Part of what the frustration that I hear from the community is that the investigation of the police in an initial incident is conducted by the department. So, their supervisor and then his supervisor and then chief internally that we look at it. And so I understand not wanting to inundate them with a number of frivolous claims, but how do you, because this doesn't really fix the checks and balance piece, because if the internal part doesn't see enough merit to recommend it up to the standards commission, you're kind of still at square one to where the police are policing each other. How do we address that part of that with this?
Well, I think a lot of it has to do with the other areas that we're talking about, making sure that agencies have practices and procedures that have checks and balances built into them. And through accreditation, there are a lot of agencies that aren't accredited, that don't have the checks and balances in place that hold them accountable to their accreditation as well. And that's, part of the disciplinary process. When an accrediting team comes to my agency, they look at sustained complaints and they ask the questions of the agency. Why wasn't this particular complaint sustained, or what happened to this officer, or did this officer get training? So some of it is going to self-correct if we have these other checks and balances in place. Now, the commission can take on thousands of use of force complaints. I see what you're saying, but a lot of it is going to depend heavily on the agency to have other oversight with the civilian review boards that we're talking about, to be able to look at some of these complaints and have recommendations. And if we don't put those checks and balances in place, I don't think the commission is going to be able to handle looking at every use of force complaint that a department, and when you think of how many departments around the state. But I understand what you're saying, but I think it's going to have to fall into some of the other mandates that we have recommended, especially through accreditation processes. I think that is going to be critical to have accreditation process, because this is going to push agencies to change their policies and procedures in the first place, those that don't have best practices in place.
So as we're looking for, you will find some good departments, some who have the resources to be accredited and to do those things. But as we look to make this a uniform thing, is there something that can be put in there that says if these 3 or 4 things occur, it's automatically sent up? I mean, to the standards commission, whether they do anything or not, you have to notify them. That's the first question, because, and I'm being a devil's advocate for a moment. I'm just saying that there's a brotherhood that's built within the department, okay? Because, kind of like the military, what have you. Then that being that any complaint starts internally and does not have any type of requirement that it goes further, until these review boards are set up, until there's a third party situation, how can we address to say that, let's say, I don't know what rules exist now, but if a taser is deployed, is that something that they automatically review?
Yes.
Okay. If there's physical contact, someone, knocks down someone, if there's an altercation, is that automatically sent up?
And it'll go back to what I was saying, Mayor, about an accredited agency. Yes, an accredited agency will have a use of force report that's automatically done on a taser deployment. It would have a form that's automatically done on a show of force, whether a weapon was used or not. It's just that there's certain agencies that don't necessarily have these policies in place right now. So the reporting could potentially happen, you know, in some manner, or it may not happen at all. So,
Sorry,
yeah.
So the last part I'll ask about that. So if it is automatically done in an accredited agency, what happens to the report? Is that something that is just kept in their file, or is automatically sent up to standards?
So part of the reporting process, that data is kept and analyzed so that we can identify officers that have shown patterns over a period of time. And those patterns are addressed either through training, through counseling, or even potentially through some disciplinary action or reassignment. It's not that we just grab these reports and continue to, you know, stockpile them. We use that data to make informed decisions about actions, assignments, or even employment. But to your point, there could be a threshold put in place to say if an officer received 3 use of force complaints in a 12-month period, that person's file should be submitted to the commission for assessment. You know, you can always put some you know, some guidelines there. Leslie, you got some ideas about how that might work?
I think you're exactly right, Chief. And, you know, I think that the universe that we're talking about here is the universe of mid-level repeat offending officers, right? Because the serious use of force incidents that we defined in our previous recommendations that are going to be investigated by the SBI, those are going to go to the commissions. They're also going to go to the civilian oversight boards, who can also recommend them to the commissions. So those high-level things, I think, those are going to get recommended up. It is the mid-level uses of force that don't always rise to the level of what the SBI might be called in to investigate, and the pattern there developed by officers, and how do we capture those those frequent flyers, I guess, and make sure that their patterns are investigated. So I think, Chief, you're spot on when you say someone who has more than 3 use of force incidents in a 12-month period. I mean, to me, I only have the anecdotal experience, and certainly being a prosecutor instead of a law enforcement officer, but we hear the things and we work in the same universe. And if someone, that would be very uncommon. Yes. It would be very uncommon for a person to have those types of use of force incidents on their record, especially in that time frame, because most officers have maybe 3 in a career, in a 30-year career, right, if that. And so I think that if we do set a threshold or recommend the standards divisions look at a threshold, that is a way, Mayor Colvin, to capture that mid-level repeat frequent flyer officer.
Well, I think we got 2 things here, and I certainly I'm following you on that. That's probably a good thing to have either way. But if you use and apply the same criteria that the accreditations departments handle as to when you fill out this form, or when you take these steps toward tracking a pattern, what I'm saying is that right now that information is stored and tracked internally with the department, right? So you're watching John Smith, Officer Smith, and if he continues to get 3 of these write-ups in a certain period of time, and the write-ups are kind of guided and the criteria is set by the accreditation, but right now you're the only one who captures his write-ups unless it's referred outside. So question is, if you apply those same standards and just allow someone else to, or let's say that there's not a periodic review on his situation after the 3rd incident, right? And you know, you're busy, you're dealing with everything that you deal with, but there's not a review. Not that you tried to overlook anything, but you're just busy, you're short of help, you're down officers and you just haven't looked into it. Is there a way that you apply that same standard to where the notification could be just given to the standards? And maybe they do nothing with it, but at least it has an outside agency that's tracking that in addition to the agency. I mean, that was the thing I was talking about.
Yeah, I hear exactly what you're saying, Mayor. And I think that's the beauty of what we're doing right here. It is creating that accountability where it's not just me as a department. If we make this recommendation, it could be what Leslie is writing here at 3 or more. This is recommended to the commission for review, so that even if it's, and to tell you the truth, even if it's not sustained, if there are 3 incidents of use of force that are not sustained with one officer in 1 year, my antennas are going to go up, because the likelihood of that officer really, not being culpable is probably, some issues there. There may have been, something in the investigation that wasn't looked into in deep detail, or whatever the case might be. But I think this gives us an opportunity to push these investigations to a higher review, regardless of what the agency has concluded as it relates to the incident. And that's why we have these built-in sort of, if someone in my department gets 3 courtesy complaints in 6 months and all of them are not sustained, what are the chances that 3 citizens said that this person was discourteous on all 3 of these different, he's doing something. So it gives me an opportunity to take a closer look at the officer's behavior.
Chief, does that language capture what you were thinking about? We've got the when it's sustained against an officer, or when an officer is reported. I use the word reported. Does that capture for 3 or more use of force incidents within a 12-month period? Within a 12-month period, yes. And I know there may be some additional wordsmithing once we get to the commission of what the numbers should be, what are reasonable numbers. Right now, 3 or more use of force incidents within a 12-month period, I think is reasonable, whether they're sustained or not. That would raise my concern.
So Chief, let me ask you a question on that. You said a lot of times the officers may not get 3 in a career. Is 12 months too low of a threshold? Because let's say he gets 3 in 18 months, that means he doesn't meet the criteria, right?
I think it's reasonable. I think it's reasonable because you could, a person that is having some real issues, I wouldn't want him to get to 18 months. Maybe I'm not understanding what you're saying.
Yeah. So in other words, the criteria of the amount of people that this would impact. Let's say you have an officer that has a pattern of doing it, but he may not do all of his 3 incidents in a 12-month period. It may be 13 months. But according to the way you've written this up, he would not be referred. You see what I mean? And so the net is not as wide as if you said someone who had 24 months, because that shows more how he normally behaves. Mm-hmm. That it's just like probation, like you give it a shorter probationary look. That if you get 3 tickets in a 12-month period, you lose your license.
Right.
But if it's a 3 tickets in a 5-year period or 3-year period, then that gives me more of a realistic point of view. I mean, because you may only capture half of 1% of people who committed in 12 months, and he really may need to come off the street. He just behaved himself for the last 3 months of the year.
And if the agency is working correctly, you could have an officer come off the street after 1 incident. Some of the incidents are, and that's trusting that the agency is doing the right thing and dealing with these situations the way they should. But I understand your point about widening that window. And that's something I think will probably need to be discussed, because different agencies have different thresholds depending on the number of officers, not necessarily the number of officers, but the type of incidents that may occur. I'm a busy department, it's easy for my officers in the field to have several complaints. And quite frankly, after really looking into them, some of them are frivolous complaints. Some of them don't amount to be anything. But because they're three, do I send that to the commission? But I don't know that we're going to get to the answer here, but I think just this is a good baseline and a starting point. It doesn't have to be 12 months. It could be, a different period, to your point.
Yeah. Representative Gallagher, what you think?
I think as the chief continued talking, my concern maybe got spoken to. I was two thoughts jumped up for me. One had to do with, is there a relationship between frivolous complaint submissions from the public and the, how can I say this tactfully, the type of assignment an officer is given? I would imagine there's some environments that are perhaps lend itself more to the potential of a frivolous complaint. And so is there any, I'm trying to create some parity with officers. Yeah. So every assignment is not equal. And so I just want to, can you speak to that at all?
Yeah, and Representative Gallia, you're speaking like a senior commander. And it's absolutely true that's why we try to rotate officers out of certain positions, because what happens is if you have an officer that is working, say, violent crimes, and that's all he's working, only people that he's dealing with are those individuals that have the potential to be violent or to fight back. Those officers are going to get a lot more complaints than your normal patrol officer. So for certain officers, it's not unreasonable for them to get a number of complaints. And some of the complaints that they get, quite frankly, are very frivolous. I mean, that's why our body cameras help us to support what an officer did or didn't do. If they say that the officer slapped him and I look at the body camera and the officer was saying, yes, sir, and yes, ma'am, the whole time and didn't, have any kind of physical contact with the person that was outside of, their scope of responsibility, that's a frivolous complaint. Or somebody said that, well, he cussed at me. Well, the body camera showed that he didn't use any profanity at all. So to your point, certain officers that work in these environments that put them in those situations, they will get more complaints. And that's not just, here in Durham. That was my experience, in Atlanta too. So, and that's just part of the job. We go through those complaints, make an evaluation of them, just like any other, and hold officers responsible. But I think when we set these thresholds, whether they're working in specialized units or not, they still will go through a process to be evaluated.
Got it. So Chief, is there a threshold for you as a chief where, from a career perspective? So I was trying to get at Mayor Colvin's point about, what happens when we go into the 13th month or the 18th month or whatever. So from a chief perspective, is there a number of complaints that once an officer receives within a career, that kind of when I'm 5 years in and this is now my 5th complaint, does the radar go up or not necessarily?
Not necessarily, especially if it's an officer that's on patrol. On a day-to-day basis, officers are responding to, some very contentious kinds of situations. And many times it's not the best of circumstances, whether it's a domestic violence situation or, a situation that turned bad once they arrived on the call. 5 years, 3 complaints on a patrol officer. I would be concerned if I saw that all 3 of those complaints were use of force complaints. I wouldn't be concerned if, there was a use of force complaint, an improper reporting complaint, you know, that type of thing. But I think, you know, my experience probably shouldn't be the sole factor. It might need to be a broader conversation with even, you know, other chiefs that have agencies that aren't, you know, as involved. For me, my eyebrows would raise, or my concern would raise with an officer that, and that's why it just kind of came out, you know, 3 complaints in a year on use of force, whether they're sustained or not. I'd want to look really closely at this officer before I go into another 12-month period. I'd want to, you know, take a deeper dive into who he is, what these incidents were, and whether or not there's something that needs to be done.
Okay.
All right. Well, I again, this may just be a starting point that when we make the referral up to the task force, that maybe we can have some input. I know you have Henderson, who's a defense attorney, who's, you know, he's real good on the legal shield portion of this conversation. So maybe we can approve this, you know, basically leaving the options open to discuss the threshold.
And Mayor, I don't know what the possibilities are of even sending this through the North Carolina Chiefs Association as a survey question. I think getting input from, you know, our other chiefs, they respond to those questions. You know, as far as what would be considered a concern for an agency, just to see whether or not we're sort of getting close to, you know, what that time frame should be. That's just a thought.
Well,
I
Chief,
agree.
you know, I think we might run up against the report deadline to the governor for sending that. But what we could do is add that specifically as a recommendation that we consult with the chiefs to get their take on what the appropriate time.
Yep,
frame would
that's
be.
a good idea.
Would that also include the Sheriff's Association?
Mm-hmm.
All right. Well, I'm fine with that. Representative Gallant, does that work?
That works for me. I'm going to actually call my chief today. I'm curious.
Yeah, me too. All right. Ms. Leslie, where is it indicated that the Citizens Oversight or Review Boards have the ability to refer things?
Mayor Colvin, that is in our recommendation that we passed for civilian oversight boards. If you give me 1 second, I can pull that up for you.
As long as it's in there on the other side, I mean, it was probably there. I don't think we talked about that specific piece, but as long as it's in there, I don't have to see it.
It is here we go. Recommendation 5, registered civilian oversight boards, and I think that we need to change. I think we changed the word registered after the task force vote. Civilian oversight boards shall be able to make the following recommendations upon completion of their review. Recommend recommendations to the agency and recommendations to the commissions. And so that passed the full task force. That civilian oversight board should be able to make those recommendations to both the police or sheriff's agency involved and also the commissions.
And let me ask you another question. When recommendations, when complaints hit the Standards Commission or the Sheriff's Oversight Board, is that public information? Can I look up and see that John Smith had 22 complaints?
At a certain point, it definitely is. And Mayor Coleman, I cannot recall the point it becomes public. I don't believe that when the Standards Division initially receives a report that it's public at that moment, but they conduct an investigation. then it goes to the probable cause committee. And I believe the fact of it going to the probable cause committee is public, but certainly at the point where the probable cause committee of either commission finds probable cause, the fact of whatever happens next is public information. So if the officer accepts that finding of probable cause and accepts whatever sanction the commission gives them, then that ultimate sanction is made public and that's kept track of at that point. If the officer wants to go ahead to contest the case in the Office of Administrative Hearings, that is public from that point on, just like a criminal case would be public, that case and the information is public from that point on through OAH, back to the commission for final agency decision, to the Superior Court for any appeal, which is called a petition for judicial review, and then through both courts of appeals in North Carolina at that point. So all of that would be public at that point. The standards division to that point is consistent with what's here on the screen in recommendation 5. The standards division at DOJ is currently working to create the publicly available database on the DOJ website for all of those actions that anyone can search via officer name. So if you have a particular person, if you're an agency head and you want to hire them, you can go in and search and see what's up there on the database. I mean, as an agency head, you can also contact the commissions. But if you're a citizen and you want to find out if an officer that you've had an interaction with has something with the commissions, has had a disciplinary action with the commissions, you'll be able to go put their name in and determine whether or not they have had actions by the commission. So that will be something that the standards divisions are currently working on. And my last report on that, I think that we may even be able to have that up and running by the first of the year. But that one will, I think, continue to develop and evolve. And I'll just also tell you that within the CJ Commission, we have had a lot of discussions at our commission meetings about making sure that information is out there and is publicly available for folks.
Okay. All right. Do we need to stop?
Does this subsection D capture the sentiment there? Chief and Mayor Colvin and Representative Geyer, the surveyed chiefs and sheriffs to gain their input regarding appropriate timeframes for use of force reporting.
I think so.
Yes.
Now, how does that coincide with what we have in the paragraph that actually says 3 or more?
So I think this right now is a recommendation, and in order for it to go to each commission, it will come out of the task force into phase 2 of the task force and become part of a recommendation packet to each commission. And I think that, and Jasmine, correct me if I'm wrong on this, but I think that there will be an opportunity at that point that if we gain some feedback that's different, then perhaps we will be able to adjust accordingly on our recommendations to the commission as part of phase 2 of the task force.
Yes, that's right.
Okay. All right, so as we wrap up the first section of the recommendations, are there any other changes, or could we get a motion to approve the recommendations as listed in 4 and 5?
I move that we approve 4 and 5 as recommendations to move forward.
I would second that motion.
All right, so it's been moved by Chief Davis, seconded by Representative Gallard to approve. Any discussion on the motion? Those in favor, show of hands or aye.
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 All right, motion carries. All right, section 2, recommendation on psychological evals. So.
And so this, the need for recommendation, we talked about in the very beginning. I almost want to say it was our very first meeting where we talked about the mental health of officers and sheriff's deputies, mental health of criminal justice officers, and whether or not there should be a psychological evaluation. And if there should be a psychological evaluation, should it require both the initial testing and an in-person evaluation? And then we also talked about at some point, should that be revisited periodically, either a certain number of years later or say before promotion to a command position, that kind of thing. I will tell you that the CJ Standards Commission has stood up a psychological screening examination advisory group, and that group has been working for about a year now studying this issue, and recently have rendered their report, and I have copied the recommended provisions here, and this was also in your packet and is also on the share drive. And these are the recommendations, these 7 recommendations from that advisory group. Next week is our quarterly CJ meeting, and we will be taking up at our meeting the approval of these recommendations for the Planning and Standards Committee, and then we will recommend them to the full commission if approved by the committee. So this is in place and it's in motion with the CJ Commission. Usually with things like this, advisory groups, when we look at this and pass recommendations, we also share that with sheriffs. And there is a line of communication there that they then get the same report, even though, and the advisory group may have also included folks from sheriffs. I would have to go back and look at who's on the advisory group. But usually the 2 commissions work in tandem on things like this and get the reports from advisory groups and then take it to their respective commissions for vote. So these are the things that the commission will be voting on next week. You'll see these are recommendations of certain things that should happen. They will all require code revisions. So the vote next week for the commission will be whether or not to recommend that we start the rulemaking process to change the code provisions here. I think the initial question is whether the task force feels like these recommendations are recommendations that it supports, and whether it wants to then issue a recommendation saying we support this, or something that is not quite as specific as supporting these 7 recommendations, but supporting the commissions and looking into this, or whether the task force wants to initiate its own, we think that X should happen. And so I think that that's the point for discussion here. So to run through briefly what the recommendations will be, that police and community corrections, which means including probation and parole, candidates should have a written test and also a clinical interview. What that carves out is corrections officers. So corrections officers are also certified by the CJ Commission. So this is requiring basically the written test and the clinical interview for individuals who are on the street, so to speak. So police officers and then probation parole officers, but not for corrections officers who are in an institutional setting. Then all pre-employment psychological screening for corrections officers, juvenile justice, local confinement, meaning in that jail personnel, local confinement facilities, juvenile or chief court counselors shall include the written test and then a clinical interview if the results identify issues. So it draws a line between when a clinical interview is mandated and when a clinical interview is optional based upon the results of testing. I will say that the advisory committee, and in reading the full report that Commissioner Hendry has drafted, they have spent a lot of time hearing from experts. There were doctors on the advisory group. They've talked about what best practices are in a clinical setting, and opinions differ. There are 2 definite sides of opinions. One believes that there should always be a clinical following a written, and the other believes that there is a place to draw that line. And I think the line is drawn here between individuals who are out in the public with the community and individuals who are in a corrections facility or in a jail facility. Then 3 is that, I think that, I don't know that 3 is something that we want to weigh into, certainly talking about only screening folks after they've gotten a conditional offer of employment, talking about rehiring, and number 4, after a break in service, Then number 5 is revising to authorize military licensed psychologists. And then defining responsibilities, position, essential job functions. And then 7, conducting them in accord with the education, training standards, regulations, and guidelines, and then other appropriate standards. So I think really what we're talking about, 3 through 7 are kind of how to get this done. 1 and 2 are the meat of who should receive what kind of evaluation. And the question is whether we want to support these recommendations, whether we want to support generally the work of the commissions on these recommendations, or whether we want to make our own recommendation, if that makes sense. And I'll also note that currently, I think as noted here, it is required in the CJ code for psychological evaluation, but not currently required at all in the sheriff's code, as Sheriff Ingram noted for us at our first meeting.
Okay. I guess we'll try to get your thoughts on this. One, I think the obvious for me is consistency. If CJ's requires it, then maybe it can be a recommendation that the sheriffs would also require the same thing. But I guess the crutch of this is we like to accept his recommendations and the others presented by the task force or create our own. So defer to you two.
I would agree that this recommendation, at least for some consistency across agencies, should be adopted. Isn't that what we're talking about for our corrections officers here?
I think for corrections officers, Chief, we're talking about, to the extent that corrections is divided out into probation and parole in one bucket, and then in facility officers in another bucket. Probation parole falls into the same as police officers, must have a written and clinical. And then jail personnel or prison personnel officers must have a written and only a clinical if the written shows that there is some area of concern.
Of course, that would have funding implications as well, but you know, the nature of the work, I think is certainly warranted, you know, for that level of an evaluation for folks working in institutions. They deal with the same types of pressures and stresses that police officers do, if not more. You know, police officers can go to work and not have a call all day long, but when you have corrections officers, they're dealing with, you know, situations every day, all day.
Yeah, I would agree with that. I'm just so I'm clear, Leslie, this is strictly, these recommendations are strictly on the pre-employment side.
That's right. So they don't yet address additional or reevaluation, which is something we talked about early on, reevaluation after a period of years or reevaluation before promotion. So our recommendation could suggest to the commission that they consider that aspect of it. I will say, based upon my involvement in the conversations thus far, as the chief notes, there is a large piece of the discussion that centers around the inability to have the funding to really do this.
Yeah, I mean, I'm definitely in agreement that there needs to be a pre-employment screening, psychological screening and evaluation. I guess I thought we had addressed the ongoing nature of this in a previous recommendation, but I guess we didn't.
We have talked a lot about it, Representative Gallagher, but it hasn't yet come to a formal recommendation.
So is there a, I guess an appetite, so to speak, Chief, regarding the ongoing nature of psychological evaluation? Because I mean, to your point, I mean, these are very, very stressful careers, and to suggest that it doesn't have some level of impact on people, and then we don't have an ongoing way of evaluating that, seems not a good policy to me.
Well, I think if we're going to really take a bite off of, into this, I believe that we need to go all the way with it and make the recommendations that help improve these systems that have had problems from the employee standpoint, and from the policy standpoint. I really believe that the employees that work in these environments should have those evaluations, because people don't raise their hand and say, I'm having a problem or I'm stressed out today. They just put the uniform on and they go, and it manifests itself into some kind of catastrophe sometimes.
To that point, I mean, what I hear oftentimes in the community, and quite frankly, I hear it amongst officers, because I think those in the community in and of themselves wouldn't know. But oftentimes what I hear regarding the current pre-employment process around psychological screening is that it's just everybody knows what the right answer is, and you just give them the right answer. And there's really no real screening, because, I mean, you're not going to raise your hand day one as you're being screened and, to your point, own all the things that you might potentially be struggling with. And so is the pre-employment screening psychologically that we have even, is it even designed to capture when people actually do have problems?
I think there is some merit to, taking the exam and the evaluation. However, at the onset, but most of the time, problems don't exist until after a person has been on the job, and all of these stressors come into play, after the 2, 3, and 4 year period. And most people are okay when they come on the job, Most people can answer those questions, because those questions are good cop, bad cop questions, and if you know anything about those kinds of exams, you can probably easily, pass the exam. We've had very few failures on that exam. And I think the failures are not necessarily about the character of the person. It was more about their understanding of the questions sometimes that they're being asked. The evaluation of the staff clinician is the evaluation that probably has more merit than anything. That one-on-one interaction where there's a deeper dive into who that person is and what their intent is for having the job, some of their personal life experiences. I think that's where, you really start peeling the onion back and finding out about the person as a whole. So the entry level, I think it's important that they have it, but I think there should be some type of ongoing evaluation process as well.
Chief, I had a question about that. I'm in Fayetteville with Fort Bragg, and you have a lot of guys make it out the military, come to police department. How do you make sure that things are right on the front end? I know you said a lot of the stressors come in as they do the job, but what about a guy that may have PTSD that no one knows about, or may have come from a war environment to now patrol the streets? How do you check on things like that?
And that's where we really rely on that staff clinician, that person that's asking the questions, and their experience in identifying, some of those traumas that might exist, with individuals. And unfortunately, sometimes it manifests itself, later on the job. People know how to go in and have a good interview. But if folks have had wartime or experienced traumatic kinds of situations, they could potentially overreact you know, in certain kinds of situations, we very seldom have officers rejected because a staff clinician noted that in their written exam, they thought they may have some PTSD kinds of, you know, problems. We've had some rejections from domestic violence, from a person that, you know, had problems in their personal relationship with their mate, but not very many that were rejected due to the fact that they had PTSD, or, you know, there were some indicators that that person may have some tendencies to overreact in situations. That's where the employees, the early warning programs that we've talked about before, that's how, you know, best practices, agencies that are running their department and having those checks and balances and have peer support programs where officers are empowered to help report the behavior and the signs of, you know, problems in the officers at that peer level. Because when you get to that club kind of, you know, conversation that we were having earlier, that thin blue line conversation, peer support programs are being more and more accepted by officers, because a lot of officers are, quite frankly, afraid to work with other individuals that can't seem to hold it together, and they want systems to be able to report without there being ramifications in the reporting. So the psychological piece, I think, has more tentacles than just an exam. It really needs to be sort of embedded in the department, and that could be part of accreditation. That's also one of those mandates, that you have systems in place that help officers or identify officers that exhibit these kind of problems. As part of those trends, evaluating the data on use of force, person could easily be flagged with some kind of issues because they've got 4 courtesy complaints or 3 use of force complaints. And that sort of, you know, and then we send them to a fitness for duty. Most agencies have fitness for duty processes. And you send an officer for a fitness for duty when they demonstrate these types of behaviors, or the potential to have some behavior that's not congruent with what we think an officer, you know, how an officer should behave. I know I've said a lot, but this is another one of those areas that I think we've got to start right here. But the work would have to be done probably with the commission, Leslie, on what, I know we've already done a lot of work with the commission on this, but at least this is a start for a recommendation.
And I do expect the discussion to be robust next week surrounding this issue. And so the questions I have then, I've just kind of drafted up a few based on how I've heard the conversation going. The first one is, do we support generally the work of the advisory group, or is it to a certain extent, or with additions or deletions? Do we want to recommend support for that? And then do we want to recommend that the Standards Commissions consider repeating evaluations? And then do we want to recommend that the Sheriff's Commission codify it where it is not currently in the code? Currently it is in the CJ code, even though it is not extraordinarily clear in the CJ code, which I think was the impetus for this working group. And do we want to have that, recommend the sheriffs have that in their code as well?
So question, Leslie, are these the only 3 out of the 7 that we're moving forward that we would address?
So to that point, Mayor Colvin, the 7 are, you know, we have 1 and 2 here. Then 1 basically says all police officers and probation parole get both a written test and a clinical. And 2 says that everyone who's in a jail or community or confinement or a detention center or anything like that, prison, have a written test, but only a clinical if there are red flags. So recommendations 3 through 7 are kind of just technical how you implement recommendations, which I'm not sure that the work group and the task force maybe want to dive into. I put them here just so that you could see what those recommendations are and for completeness. I'm not sure 3 through 7 are anything that we necessarily want to weigh into. They're not the policy questions, so to speak. 1 and 2, I think, are the policy questions, that whether we feel as a task force that there should be psychological evaluations, and if so, what should they look like? It is also possible that we could say we do feel like psychological evaluations should occur, but we leave that to the commissions to decide. If we don't have, if the working group and then the task force doesn't have a particular opinion about that, we could leave it to the commissions to decide. Or we could say that we support the way that the advisory group has drawn these lines here. I can't guarantee that the way the advisory group has drawn the lines is how the Planning and Standards Committee will vote next week to accept these. And I also can't guarantee that that's how the full commission will vote next week either. It is a very contested topic. And so by supporting this, it might not ultimately be what passes the commission, or does the task force want to formulate its own recommendations? So I think that's kind of question 1. And then question 2 on repeating is not something the commissions have addressed, and whether we want to suggest they do. And then question 3 here is, I think that at base, even Sheriff Ingram indicated in our very first meeting that it's not in the sheriff's code, it should be. So 2 and 3, I think are not anything that is currently before the commissions. But number 1 is, do we support what's currently being recommended to the commissions?
Okay. Representative Gallant, you have anything?
I think this is going to be seriously debated. I'm wondering, so my thought, I'm struggling a little bit, because part of my thought is we need to go all in on this. And then my other thought is, you know what, we need to walk as gingerly as we can just to get this ball rolling and make sure nothing gets voted out. And so I'd rather, as much as I'm usually an all-in guy, this is my personality, but I feel like this is too important of an issue to walk away with a loss on this one. And so I'm just wondering if we really take a minimal approach on this, just to get, the language introduced, get people on board, and then over time we can make it more robust as time goes on. And so I do have a clarifying question, Leslie. Am I understanding correctly that currently then only police officers are going through the pre-screen, the pre-employment psychological screening, and not sheriffs nor correctional officers?
So corrections officers are. Let me share my other screen with you. I've got the code provision here. Corrections officers are governed by the CJ Commission, just as the police officers are. This is the provision in, it's 12 NCAC 09B 0101. So this is here, we're talking about minimum standards for criminal justice officers. And down here, one of the minimum standards is, have been administered a psychological screening examination by a clinical psychologist or psychiatrist, licensed to practice, etc., or with the armed forces within 1 year prior to employment by the employing agency to determine fitness. So as this stands, it doesn't necessarily say you first have to have a written and then a clinical. It basically doesn't go into it. And the lack of clarity is part of what the advisory group has been looking at for the past year. And I think that where they have landed with it is that the code's not clear about written versus clinical, and that they want to recommend both written and clinical for anyone who is a police officer or probation parole. So people who have direct contact with the outside community for initial interactions. And that then they want to recommend for those who are working as corrections officers in confinement facilities, who right now do have to have this, what is called psychological screening examination. It doesn't further define, but the advisory group has said psychological screening for that subsection of folks should mean they take the written test, and if there's a red flag, then they have the clinical. So I think that the recommendation will be to revise this code provision to be consistent with those two recommendations, if that's what passes. But I will tell you, there is also a camp that says everyone should have a clinical. And so that's the discussion. This right now splits the baby and says you only have a clinical if you are in a forward-facing, outward-facing job, police officer, probation, parole. But you have a clinical if you're a corrections officer, only if there's a red flag on your written. There is another camp of individuals that says everyone should get a clinical. And I think that's where the debate will center next week before the commission. So I think that no one disputes that there should be psychological screening. I think that how to get there and what it means is perhaps where the discussion will center. And this same code provision you're viewing now doesn't exist in the sheriff's code. So that's why I say a recommendation could be made to the sheriff's commission to put it in there.
Yes. 2 minutes away. She's
All right, so we good on that. I kind of agree with Representative Gallup just to get the conversation going.
I'm headed down there. I apologize. I know I probably look like I'm multitasking here. I've got a press conference in 2 minutes, y'all.
You got to go. Let's vote on this recommendation so you can go and get ready for the camera, Chief.
No, I don't want to get ready for the camera.
I know.
So I think 2 and 3, you guys have indicated you want to do. Recommend the standards commissions that psychological evaluations be repeated. The question is, do you want to set a number of years or before promotion, or leave that open for the commissions to discuss? And then number 3 is that sheriffs put it in their code. I think those two are fairly.
I think both of those are fine.
Yeah.
And I think the commission would probably need to really look at the years. I think they're going to have some opinions. I do agree with Representative Galliard. This is one of those that could sink if it's not carefully thought out, and it could sink quickly. It makes sense, but I think we need to take our time with making sure that the language at least gets through the door, gets through the gate. I'm going to have Deputy Chief Sherry Montgomery sit in if there's some more discussion. She's over our training and all of that. And I'm going to run downstairs real quick. Sorry, y'all, I have to leave.
So do we?
No problem. We're watching you on TV.
Okay. Do we need to vote?
That's right. That's right. And we are losing our quorum. So, we could take a vote later via email if you wanted
Okay.
to.
Yeah, that'd be fine.
That's fine.
Sorry.
Thanks,
All right.
Chief. Good luck.
Well, Mr. Musa, I'm not sure. I mean, we covered most of what we had planned for today, and we don't have a quorum to really make any substantive decisions. Anything else we need to cover before we jump off?
Well, unless you want me to schedule a meeting for you for next Thursday.
I wouldn't say that's what I wanted. But
I know y'all are tired of me scheduling meetings. So I think Mayor Colvin, this is our last working group meeting. We have a full commission meeting tomorrow where we're going to vote on our working group recommendations from last week. So these recommendations, if we want to go forward with them, will be voted on next Wednesday at the full commission meeting. And so I think that we need to get them out of committee, if not today, then via email vote. So what I would recommend is that Representative Galliard and you and I kind of talk through this language for these 3 recommendations and get it where I think you want it to be. And I will email it to all of our groups or all 4 of our voting members. And we can take a vote that way to get it out of committee. And then it can be presented to the full task force next week, because this is the last issue that we have flagged to discuss. So I think if we can get it across the finish line here in the next few minutes with drafting, and then I'll send it out for vote, hopefully we can get that to the full commission next week.
Well, yeah, and I appreciate that. I'm not necessarily opposed to how you have it drafted. I mean,
Okay.
I listen to Representative Galliard. It Did you
Yeah,
say?
I'm not opposed either. I don't know that we should commit to a number of years ourselves. I don't know that, I think there's going to be a lot of pushback on that. We might want to get a broader commission to weigh in. I do have a clarifying question, Leslie, as it relates, as I'm processing the whole conversation for the day, I realized we hadn't really brought the highway patrol into this conversation. And I'm wondering if perhaps they are operating at a standard that might be beneficial for us to try to let become the standard. And so do you know where highway patrol is on this particular psychological evaluation piece?
I do, yes, sir. They are considered with the police officers. They are, their certification is held by CJ. And so they are what we would consider part of this, they would be considered police officers in terms of the criminal justice officers covered by the code. And right now are receiving both the written and I think psychological, even though I think DPS is divided, right? Because they have highway patrol, FBI, ALE, and then corrections, all under the DPS umbrella. The policing arm, the externally facing policing arm, I believe are all receiving clinical evaluations, while the corrections arm is perhaps doing it the second way, where there's a clinical if there's a red flag. And so I think that highway patrol is in fact doing it along the lines of the first recommendation.
And you could answer this by way of email, because I know we've left it, but I would be curious to know if there's a different standard for highway patrol and the use of force incidences and how they get reported. You know, that conversation we were having, like, 3 incidences in 12 months, something like that. And that's really, Leslie, just to prepare me for the ongoing discussion in front of the bigger committee.
Yes, sir. I will find out what their use of force reporting looks like and email you.
And I apologize for raising that after we'd already left it, but.
Not at all, not at all. I will get that information to you. So I have adjusted this here to say either after a number of years of service or before promotion, to be determined by the commissions after further study and discussion, if you're comfortable with that language. And then supporting the recommendations of the advisory group. Is that the will of the group, is to support those recommendations?
Well, of course, we don't have a quorum, but I guess these questions you can send out in form of a vote, and we can email our preferences.
They are, that's right. And I think that it's either, Mayor Coleman, I think it's either support what they're doing or say, we support the work you're doing, but here's what we think it should be.
Right.
So I think it's probably, one of those two things.
Okay. All right. Well, we'll look for you to send that out today, I guess, and leave way for any questions. I know Sheriff Ingram may have a few questions since he wasn't present for the discussion today, but other than that, seems like we've come to the end of this long road here. So,
it's been a journey.
Yes, sir. Yes, sir. But I do appreciate it, Leslie, and all of the support team. You guys have been great to work with. Been a lot of work, and you all have kept us on task, and I appreciate that. Representative Gallup, absolutely appreciate your commitment to everything, and same with Sheriff and Chief Davis. So we will look to answer that. We'll look for our full committee meeting tomorrow, and then the final committee meeting is Wednesday, you said?
Yes, sir, the 18th.
Okay. All right. Well,
Mayor, just before we just adjourn, I do want to just commend you on how you have presided over the work group. I think you've done a great job, and I have enjoyed working with you. And Leslie, you're a rock star, man. You guys doing what you do, you make us all look a whole lot smarter than we really are.
all right.
At least me anyway.
Me too.
I appreciate that. Thank you. It has been a pleasure working with y'all. I might just schedule a Thursday meeting just so I can see you then.
All right. All right, guys. Well, with that, I guess we'll jump off, and we'll see you tomorrow.
All right. Thanks, everyone. Have a good one.